Hi, this is attorney Andrea Witt.
And I'm attorney Stephen Spano with a legal and financial minute or two.
Today's topic is a cautionary tale about making simple changes to deeds.
A young man recently consulted us for some help. We'll call him John. John also has a wife. We'll call her Jane. John and Jane have a very modest house, savings of about $96,000, and 4 young children, the oldest being 21 and the youngest only 14.
Jane is suffering from an Alzheimer's type dementia and just went into a nursing home because she can no longer be cared for at home and because the children's safety is at risk.
Meanwhile, John's brother-in-law, who's a very kind and well-meaning lawyer, saw Jane declining and told John and Jane that they needed to change their deed on their home to protect the home from the nursing home. So they met with the lawyer and they did change the deed and named their children.
As soon as she went into the nursing home, John was told he had to pay the nursing home $485 per day. That's $177,000 a year. He has a family to care for and decided to apply for Mass Health, also known as Medicaid, to help pay for Jane's care because his insurance, like all health insurance policies, including Medicare, does not pay for long-term care in a nursing home.
And unfortunately, Jane was denied Mass Health. And the reason she was denied is because John and Jane had signed a deed to their home, naming their children on it just a couple of years ago when Jane first became ill. Not only were they denied, but John was told he had to pay the nursing home out of his own funds for the next 39 months for a total of $575,000, even though he has less than $100,000.
The well-meaning brother-in-law lawyer made a catastrophic mistake. The home did not need a deed change. The home was already protected for the family because John and Jane are married. John and Jane never needed to change their deed, a change that caused Jane to be denied Medicaid benefits.
Worse yet, John and Jane have to go through a lengthy court process to change the home back into both of their names. And the reason they have to do that is because a 14-year-old cannot sign a deed. So during this entire lengthy court process, John is going to have to continue to pay the nursing home $485 a day.
Do not let this happen to you. A loving, kind, well-meaning brother-in-law attorney that helps you for free may sound like a great deal, but it may also end up costing your family their life savings.
Never sign a deed or anything else without consulting an expert for a thorough review of all of the consequences of what you do.
We hope this legal minute or two has helped you and your family protect your health, your assets, and income, and preserve your way of life.
And remember, if you have any questions on this or any other important legal or financial or health topic, call or text Spano and Dwicky at 781-231-7800 or email us at help@spanodwicky.com.